Good afternoon, and again, welcome to the second day of the July session of the Tennessee Court of Criminal Appeals. Again, we are operating under creative circumstances. For purposes of our new protocol, I want to let the parties know you can sit at council table and you can present your argument with masks on or not. And for purposes of, I guess, our audience outside of the courtroom, for listening purposes, again, I'd like to introduce the panel for today. To my left is Judge Ross Dyer from Memphis Shelby County. And to my right is our presiding judge, John Everett Williams from Huntington, Tennessee. And I'd like to once again extend my appreciation and thanks to our presiding judge for allowing me to preside today, and for all of his efforts in ensuring accessibility to the courts during this time. Again, my name is Camille McMullen, and Madam Clerk, you may call the first case.
Good afternoon, David Mays from the Shelby County Bar. May it please the court, David Mays from Shelby County Bar, representing Tyrone, Bohanna.
Mr. Mays, would you like to reserve any rebuttal time?
Yes, if I may reserve 8 minutes of rebuttal. I come before the court today on 3 issues. 1, Brady violation that I've alleged. 2, severance issue. And 3, ineffective counsel claim in a post-conviction appeal. I think it's an important issue to start with Brady, because that's a serious allegation that I've made and have been making for some time in this case. When I look at the state's response, the response is not that there isn't a Brady violation, but yet the petitioner waived his Brady violation because of a procedural issue citing the Post-Conviction Act. However,
Counsel, let me stop you just for a second. For purposes of our audience outside of court, can you put the issue in context? I understand you're presenting your Brady issue, but just for you're presenting a post-conviction appeal.
That's correct. Mr. Bohanna went to trial. At that trial, he was found guilty.
And go ahead, I'm sorry.
He's had an appeal. I was appointed on post-conviction, and in that post-conviction, I obtained discovery from a separate case. And in that case, one of the key issues in Mr. Bohanna's trial was the key state witness.
There was only one witness that identified Mr. Bohanna on the scene, and the other witnesses or victims did not identify Mr. Bohanna. So the state's case against Mr. Bohanna relied on one witness. While prior to the trial, that witness was murdered, and the state presented a motion to bring that otherwise unavailable, inadmissible testimony of the unavailable declarant who was murdered into the trial based off the fact that Mr. Bohanna had actually orchestrated that murder from inside prison. To do that, they relied on 900 phone calls, of which they chose 10 30-second sections, picked those out, presented those to the court. My contention was that at the exact same time, that same prosecutor's office was prosecuting 2 other individuals under a completely different theory, a theory which contradicted what they presented to the court, a theory which the trial court never was able to consider, a theory that the Court of Appeals was never able to consider. Only now is the Court of Appeals able to consider it. The trial court, once again, was able to consider it in the post-conviction hearing, and that's what we come here today, saying that the trial court erred by not finding that to be relevant material. And as a matter of fact, the trial court continues in their ruling to say this is a completely unrelated investigation. The district attorney, the assistant district attorney who was handling the trial also says she actually claimed that she has an ethical duty not to look into this, of which I challenge, saying, I think that you do have an ethical duty. As a matter of fact, and her words, which I've cited, are, I have nothing to do with that file. I don't want to look at that file. But at the exact same time, she's presenting to the court a very, very strong motion to bring in evidence that is their strongest evidence against Mr. Bohanna off of this exception, saying that he orchestrated a murder. And it is relevant, it is related if the same office is prosecuting different individuals under a different theory, which kind of was this romantic triangle between three different men. There was eyewitnesses who I identified who was responsible for that. Ultimately, someone pled guilty under a different theory that had nothing to do with Tyrone Bohanna. If you look at the timing in the trial court at the time, and the day before trial, when this pops up, the day before trial, it pops up, and trial counsel is saying, oh no, I need this information. The trial court at that time said, I'm not giving it to you because that information is in an ongoing investigation. However, I've included all of that information, the entire discovery packet, everything that I could. I tried to include that in the file for y'all to understand that the indictment had already happened. It wasn't an ongoing investigation. Someone had already been indicted. They were already going forward. And so when I go back and challenge the state in this hearing and say, hey, you had to turn that over. Defense counsel needed to be able to present that in the forfeiture by wrongdoing hearing. And even if the trial judge said no, then the Court of Appeals needed that information. But yet that information is not coming forth until now. The state's response in this appellate arena was that was waived. But also, what they cite, the Post-Conviction Act, they say that it's a waiver unless the failure to present ground was a result of a state action in violation of the federal state constitution. That's exactly what I'm saying it is. Like, that's what a Brady violation is my understanding. This is a state action. They withheld evidence that violates the petitioner's constitutional right to a fair trial. And so even if the court was to
Let me just back you up just a little bit.
Certainly.
I want to make sure I understand. A lot of complicated facts here. I haven't had this court generally does not go into the record before argument. But can you lay out specifically what evidence was withheld?
There was an entire investigation which included specifically statements of two individuals explaining who was responsible for the murder of the key witness, Antonio Hawkins, that was the only witness against Tyrone Bohanna at his trial. And a part of those statements was the contextual background of a woman who was involved romantically.
There are two statements, physical statements, which say someone else was responsible for the murder that the defendant was convicted of.
No, the murder of the witness.
Okay.
So, which there's statements that support the ultimate theory of a murder of Antonio Hawkins, who was the witness against Tyrone Bohanna. And
I got you.
So when you put that in context, what the prosecutors did is they came forward in a forfeiture by wrongdoing hearing and presented their circumstantial case based off of phone calls, jail phone calls, and say, oh, Tyrone Bohanna orchestrated a murder from inside the jail of this witness, and therefore we should be able to bring that witness's testimony in. However, what they did not provide was the investigation into that murder that was happening at the same time inside that same office, and which was not it wasn't a murder for hire. It wasn't a murder to silence a witness plot. It was a murder involving two different men and a woman in a hotel room. And that's where it's our contention that should have been turned over prior to the forfeiture by wrongdoing hearing, because that's exculpatory in nature to Mr. Bohanna and against the state's theory that says he's the one that orchestrated this murder.
And therefore, the statement would have never come in because it wouldn't have been a witness that was unavailable, and they wouldn't have any evidence to convict your client.
That's correct. And if, as far as a potential harmless error, say, oh, well, the court couldn't, if the court would have ruled, oh, well, we still find that he orchestrated this murder, then the Court of Appeals then would have been able, we could have argued about this after the trial in the Court of Appeals, but this is a novel issue to this case on post-conviction, and it's not waived because they didn't know about it. And the state also, in a slightly contradictory fashion, then says the trial counsel could have gotten it. He could have gotten it, and that's why it was available to him. He could have gotten it, which he finds out about it on the first day, January 31st, 11, which is the first day of motion hearing, day one of an 8-day trial. And so, yeah, I guess he could have gotten it, but at the same time, at that time, the court ruled that he wasn't giving it to him because that was a pending homicide investigation. And that's kind of been the defense of, oh, well, we're not going to give it to you because that's a pending investigation. However, the indictment had already been passed down on one of those individuals. The statements have been taken months before, and with the prosecutor's explanation, the prosecutor's explanation in this post-conviction hearing was, oh, well, I don't know what was, I don't even know what was going on in my office. As a matter of fact, I couldn't look at that because I have an ethical duty not to look at other investigations because that has nothing to do with what I was presenting. But my stance is absolutely has everything to do with what you're presenting. If you're saying that someone was murdered through a murder for hire, but yet there's a huge investigation into two other individuals that has nothing to do with that, those are absolutely related. And I think there's, in the contrary, I think there's an ethical duty that you must look at that and then you must provide that to the other side.
Did they convict? I don't think that that's necessarily relevant, but did they carry that indictment to conviction
It ultimately resulted in a plea.
of both?
I believe so. I know at least one plea. A separate issue was severance. And this is, I think it's an important issue because it's a little novel, in my opinion. I couldn't find much law to support what logically I thought was the right thing and where justice would actually come up, which is you have two co-defendants. One of them says he didn't do it. He's innocent. He wasn't there. I was there, but I wasn't involved with it. That's Brandon Harris, the co-defendants. That's his defense. I was there, but I didn't have anything to do with this aggravated robbery. But Tyrone Bohanna was not there. That's his statement. The prosecutors knew about this. The defense counsel says, we want to bring this in. Well, right before trial, the trial court severs it based off of this fact that Brandon Harris' lawyer was, Tyrone Bohanna made a comment about paying for Brandon Harris's lawyer, which in the post-conviction hearing, we cleared up in one sentence. Miss Harris, Brandon Harris's mom, who paid for the lawyer? Our family did, right? There is no actual prejudice there created against either party because it's just an unsubstantiated statement in one of 900 phone calls. Well, ultimately what happens, Tyrone Bohanna goes to trial first. And why? In the words of this prosecutor, because I did not like him because he killed one of our witnesses. Again, there's an assumption there that is our first contention is not necessarily the truth. But my argument is that there has to be some sort of balancing test because it was highly prejudicial. Of course, Brandon Harris doesn't want to go and take the stand in Tyrone Bohanna's case before he has to go to trial. He wants to go to trial and have a fresh slate. He doesn't want to give testimony ahead of time, but there's no prejudice to him after if he goes first. There's a lot of prejudice to Tyrone Bohanna for going first because Brandon Harris is unavailable. Ultimately, Brandon Harris goes to trial later, and in his trial, sua sponte says, Tyrone Bohanna is an innocent person. He's the one going down for a crime he didn't commit. Why? Because I was there and he wasn't there. Now, is that new evidence? Not necessarily, because we knew it was there. The issue comes down to severance. The severance was, it was...
Would he testify at trial, and did he testify at trial?
he testified at his own trial.
Would he
And
testify at your trial?
he did not. And so I put that both on the trial counsel for being ineffective. You've got to call him and read the transcript. Talk about people jumping on top of me saying, how dare you even consider calling a co-defendant? You can't do that. You know, I don't know. I would have done it. Maybe I'm inexperienced and I would have made him plead the fifth. And then,
Well, there's prohibitions against that too, sir.
and perhaps, and that's where they put it on me, like, oh, you can't do that. However, when we look at the final result and you have two co-defendants, it's unjust for one, when you look at their stories, to go after the other one when the first person is going to testify this guy's not involved.
We're
And
about to get into your rebuttal time. You said you wanted 8 minutes?
yes,
Yes, go ahead.
and I'm out of time on, okay.
You can close and allow the state to respond.
So ultimately, I think there should have been a balancing test done at the time. And I think that there needs to be law to protect against this exact situation where you have co-defendants and just allowing the prosecutor that randomly choose or purposely choose, however you look at it, I'm going to have this person first.
It's generally not random, and since I've been watching this over the years, it's generally the state wants their best case first. And that's what they want to put on, is their best case first.
And certainly, I think they do have the right to do that. However, when there's a severance issue like this, I think that there needs to be some sort of review by the trial court that then can be reviewed by an appellate court. Because if someone comes up and says, no, we want them to go first. Why? Because he's going to testify that we weren't there. And
Thank you, counsel. State?
Good afternoon, Your Honors. Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should affirm the post-conviction court's denial of relief to the petitioner because the post-conviction court's factual findings and conclusions of law are both supported by law and supported by the record. Here, the petitioner raises three main claims: ineffective assistance of counsel, a Brady claim, and a severance claim. And I'll begin by briefly addressing the Brady and severance, the freestanding claims. The defense counsel asserts that the petitioner has not waived his Brady claim because his failure to raise it before the lower courts was due to state action. However, it is due to the fact that trial counsel was deceased prior to the post-conviction hearing. It is a little unclear exactly how much Mr. Copeland, the trial counsel, knew about the murder of the victim, Antonio Hawkins. The post-conviction court found that he was aware of the state's forfeiture by wrongdoing hearing, and he, at a minimum, had enough knowledge to challenge it. Thus, in response to defense counsel's waiver argument, it's the state's position that the trial counsel had enough knowledge to be able to challenge it if he so desired.
How? What proof do you have of that?
Well, Your Honor, at the forfeiture by wrongdoing hearing, Mr. Copeland objected to the state's introduction of the pretrial statement of Antonio Hawkins. I believe it was at the preliminary hearing. In addition, Mr. Copeland brought in a rebuttal witness because the state's forfeiture by wrongdoing motion was based on two major sources of evidence: the petitioner's jail phone calls and the testimony of Adrian Wright. And Adrian Wright was a fellow inmate with the petitioner. And Adrian Wright testified at trial that the petitioner told him that he arranged for the murder of Antonio Hawkins, and that the petitioner was happy and excited when he found out that Antonio Hawkins had been murdered. And Adrian Wright also testified that the petitioner told him that he had used another inmate's PIN code for the jail telephone in order to make those phone calls arranging for that murder. So based on his jail phone calls, which the text of those phone calls are included in this court's direct appeal opinion, where this court affirmed the trial court's decision to admit Antonio Hawkins' statement under the forfeiture by wrongdoing exception. And in those phone calls, the petitioner made numerous statements implying that he was threatening witnesses, coercing witnesses, paying off witnesses, including one of the victims, John Morgan. He made references about co-defendant Harris's mother, and the statement where he claimed that he paid off a co-defendant Harris's attorney. So based on that evidence, the trial court followed State versus Ivy and concluded that the state had established by the preponderance of the evidence that the petitioner was involved in, at least in part, in the murder of Antonio Hawkins, and that the petitioner had a motive for that murder. Now,
But the trial court did not, I guess, know, or did the defense lawyer know that the state of Tennessee was pursuing a murder charge against 2 other individuals for that? There's only one murder.
yes, Your Honor.
And they were pursuing 2 other individuals for killing that victim on a totally different theory.
Yes, Your Honor. Again, it is
Would that not put a whole different light on the way the judge might have looked at this?
No, Your Honor. Again, because trial counsel was deceased prior to the post-conviction hearing, it is a little unclear the extent of his knowledge.
Well, the state sure didn't tell him. There's no evidence in the record that the district attorney general told him anything about this, right?
No, Your Honor. It's unclear whether Assistant District Attorney Pam Stark even knew of these statements. As defense counsel discussed, Ms. Stark first learned of the murder of Antonio Hawkins when the police officer investigating Mr. Hawkins's murder called her because her cell phone number was in Mr. Hawkins's cell phone. And so at that point, when she learned that one of her witnesses was deceased, she looked at the file at that point in time. And she was looking for connections to Petitioner Bohanna's case. And once she said, okay, Bohanna's name is not in there and Harris's name is not in there, she closed the file and did not access that file any further. However, regardless of trial counsel's amount of knowledge about the police's investigation into the murder of Antonio Hawkins, the petitioner cannot establish that he was prejudiced by trial counsel's decision or lack of bringing those statements to the forfeiture by wrongdoing hearing. State versus Ivy, which was decided by
If I had 2 different, let's have a murder case. Let's have 2 different murder cases of the same person. And I want to try 2 people for murder. And then I want to try these 2 people for that same murder in the same office. 2 district attorney general, give one to one, one to the other. Is that okay?
Your Honor, it's difficult for me to give an answer to that question just
What's difficult about it?
without specific details.
They murdered and they charged 2 separate individuals with 1 murder. They never told each other about it.
Regarding Ms. Stark's statement that she declined to look at the police file due to an ethical conflict, if that's what Your Honor is discussing.
If it's ethical conflicts that prevent that, should that occur? Should one district attorney general's office be allowed to prosecute 4, 5, 2 people for the same murder on different theories and not tell the other side that they're doing it?
Your Honor, the state never prosecuted Mr. Bohanna for the murder of Antonio Hawkins. He was never charged. He was never
used that theory that he murdered to get the only evidence in trial that would identify him in a corresponding case.
Yes, Your Honor.
They did not tell them anything about, we've charged people with murder and it's not for the same reason that we're saying you did. You don't think that makes a difference?
Your Honor, under State versus Lay, the trial court properly admitted this evidence because there's no prohibition against there being multiple motives for a murder. It may very well be accurate that Charles Townsend and Demetrius Lay murdered Antonio Hawkins in part because of his relationship with one of their girlfriends.
Should the judge have had the opportunity to say, I don't know which one to believe. I don't know if these two did the killing or this one did the killing.
Your Honor, even if the trial court had considered the statements of Demetrius Lay and Charles Townsend, it would not have affected the outcome of that hearing or the outcome at trial because State versus Lay does not limit the state into proving that the defendant's motive for murdering the unavailable witness is the only motive.
Well, it doesn't prevent them from doing that, but I think the question is, don't they at least have to let the other side know, hey, my theory as prosecutor in courtroom A is that your client is responsible for the death of my witness. So by the way, there's a prosecutor down the hall in courtroom B who thinks these other two people did it. No, I don't have to prove that he did it in order to get the statement in, but in order for the defense to have the ability to defend against it, they have to have all the information, don't they?
Well, Your Honor, Mr. Copeland did defend against it. He objected.
But it doesn't appear he had all the information. I mean, the judge who's making this determination, as I understand the record and y'all's arguments, the judge who's making this determination doesn't know that down in courtroom B, they're trying two other people for the exact same murder under a different theory than you're arguing, the state is arguing to me as the judge right now as to why I should let a statement come in.
Your Honor,
and as a defense attorney, I should be able to say, Your Honor, wait a second, time out. The state, because again, it's not just two random individuals. This is the state. Both prosecutors make up the state. So the state is presenting to two different judges, two different theories. And I, as a defendant, should be able to say, hold on, they can travel this way, but you need to have all the information, Judge, and I need to have all the information before I can tell you that.
yes, Your Honor. The post-conviction court found that Mr. Copeland, and I'm quoting from the post-conviction court's order in the technical record, volume 1, page 129, that Mr. Copeland asked for the investigatory file regarding this murder of Antonio Hawkins, for which the petitioner had never been indicted or convicted. So again, it is unclear exactly how much knowledge Mr. Copeland had of these statements. We just don't know, partly because he was deceased and he was unable to testify at this hearing. But based on the post-conviction court's finding, it is evident that Mr. Copeland did have some knowledge of what was contained because he asked for that file.
Well, isn't it at least curious that one lead investigator never asked again? She came up with her own theory about who murdered who, and she never talked to another investigator about where are you in this murder case. I know the guy that I've got charged with especially aggravated robbery did it. Are y'all going to charge him? Are you going to do anything about a murder, which is more heinous than what we've got here we've charged him for? But she never went back and asked anybody, what are you doing about this murder that I know the defendant committed? And I'm fixing to submit to a judge. Doesn't that sound a little strange to you that she would never question anybody else about that until I've got an ethical obligation not to know about that?
Your Honor, the post-conviction court found that Ms. Stark had a pre-existing relationship with Antonio Hawkins. And while she did not specifically expand on her statement that she could not continue to access the police file due to an ethical conflict, the rules of professional conduct under the rule regarding concurrent conflicts with clients states that an attorney has a concurrent conflict of interest if there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's personal interest of the lawyer. So it may have been that Ms. Stark felt that she was going to have bias in this investigation of Mr. Antonio Hawkins's murder because she had, as the post-conviction court found, a pre-existing relationship with Mr. Hawkins. And she mentioned at the post-conviction hearing that the state decided not to charge the petitioner for conspiracy for the murder of Antonio Hawkins because he received an extensive sentence in this case. And thus there was really, justice had already been done. He was already going to spend the rest of his life in jail. And so they decided not to use state resources on pursuing a charge or prosecution of Mr. Bohanna for his involvement in arranging for the murder of Antonio Hawkins. Additionally, Your Honor, regarding the petitioner's argument that Mr. Copeland should have more thoroughly investigated the petitioner's jail phone calls, the post-conviction court concluded here that that petitioner failed to establish that he was prejudiced by Mr. Copeland's representation. Ms. Starks testified that she created a transcript of the jail phone calls that she planned on moving for the admission at trial. And after the first day of trial, she and Mr. Copeland sat down and reviewed those transcripts for hours until 11 p.m. that night. And at trial, Mr. Copeland objected to the admission of those transcripts on the ground that there were discrepancies between the actual recordings of the calls and the transcripts. Thus, the post-conviction court properly concluded that Mr. Copeland, his representation as to the phone calls was neither deficient nor prejudicial. Regarding the petitioner's claim that Mr. Copeland was deficient and prejudicial for failing to force co-defendant Harris to testify at trial, the post-conviction court concluded that the petitioner had, quote, absolutely no legal foundation for this assertion when, quote, Mr. Harris and his two attorneys have all insisted to the court that Mr. Harris would not testify on behalf of the petitioner, and thus Mr. Copeland properly, quote, followed the established law and did not insist on violating ethical and legal mandates. And here at the petitioner's trial, Mr. Harris took the stand and during a jury out hearing, put on the record that he did not want to testify at the petitioner's trial. And the post-conviction court's findings and conclusions on this ground are amply supported by the record. The record includes an affidavit from Mr. Harris where he states that he took his attorney's advice not to testify at the petitioner's trial because it would be against his best interest. And additionally, in the petitioner's error quorum nobis petition, which was included in this record, the petitioner himself argued in that petition that Mr. Harris was advised by his attorneys to invoke his Fifth Amendment right. Thus, it is clear that the petitioner was not going to testify that Mr. Harris was not going to testify at the petitioner's trial. And additionally, in Duncan versus State, this court concluded in 2019 that the post-conviction court in that case properly denied relief on essentially the same ground. In Duncan, the petitioner also argued that his trial counsel should have forced his co-defendant to testify at his trial. And the post-conviction court noted that the petitioner went to trial first and the co-defendant went to trial after it, and the co-defendant's charges were still pending as of the petitioner's trial. And thus, the petitioner could not force the co-defendant to testify. And to address the petitioner's argument that Mr. Copeland was deficient for failing to raise a Brady claim in the motion for new trial, and that the appellate attorney was deficient to raise it on appeal, the post-conviction court concluded that the petitioner received effective assistance of counsel from both Mr. Copeland and Mr. Sirianni, and that there were no issues that the Tennessee Supreme Court would have ruled differently on that were not included in any of those motions. And the court found that Mr. Copeland raised all possible arguments in the motion for new trial and presented all viable issues on appeal. And here, the statements at issue of Demetrius Lay and D'Angelo Howard are not Brady material, and thus the petitioner was not prejudiced by Mr. Copeland's decision not to include them in the motion for new trial. In order for these two statements to be Brady material, they must be in the possession of the state and be material and favorable under State versus Cureton and Johnson versus State. And here, the statements of D'Angelo Howard and Charles Townsend, as defense counsel have noted, provide that alternate explanation. But those statements would not exculpate the petitioner. They do not provide actual evidence of his innocence, nor could they have been used to impeach any of the state's witnesses. And thus, they are neither material nor favorable under the Brady standard. And the post-conviction court properly concluded that Mr. Copeland was not deficient or prejudicial for failing to include those in the motion for new trial. And if this court has any further questions, the state asked this court to affirm the post-conviction court's denial of relief to Tyrone Bohanna. Thank you.
You have 8 minutes.
Thank you, Your Honor. Was it exculpatory? It was in the possession of the state. I don't think that's in dispute. And it was favorable to the petitioner, Tyrone Bohanna, because it went right at the heart of the ability to bring their key witness in. In addition to that, the trial itself was generally tainted by the way it was presented. It wasn't, here's Antonio Hawkins, and here's his statement of what happened. Tell us what happened in front of the court. They bring in all these phone calls. The phone calls, and then there's an implication that Mr. Hawkins isn't there because Tyrone Bohanna had him killed. The entire trial is tainted from the get-go. It doesn't benefit Tyrone Bohanna for Antonio Hawkins not to be there to give his testimony. It was doubly worse for him because there's an implication that Antonio Hawkins isn't here because Tyrone Bohanna had him murdered. That, and when we go back to why that's in there, Judge Williams, you asked a great question. And is it okay for the prosecutor to prosecute two different theories at the exact same time? The answer to your question is no. It is not okay. And not only is it not okay, your next question was even better. Is it okay for the prosecutors to not know about it? For her not to look into it? Well, no, that's not okay. She must look into, she can't just turn a blind eye. Was it strange that she never looked back, right? Was it strange? Absolutely, yes, that is strange that she never looked back. It's even stranger when her not looking back was very, very favorable to her getting evidence, which was the key to not only tainting the entire trial, but getting the only piece of evidence that connects Tyrone Bohanna in there, taken in conjunction with the strategy of making Tyrone Bohanna go first and keeping out favorable evidence of the testimony of the co-defendant. Innocent man wasn't there. What do we have? We have a conviction that of a potentially innocent person.
I'm afraid to ask a question due to the fact I'm in such greatness of question asker over there. But I have one question in that, doesn't the death of counsel prior to the post-conviction hearing shed an unfortunate light on the fact that your case is just hard to prove because there's no way for us to know what he knew and what he didn't know. And I say that the burden's on you, one, to prove your factual allegations of what he knew and didn't know by clear and convincing evidence. And I don't know, I guess my question really is, how do you meet that burden when there's no way for us to truly know what counsel knew and didn't know, and then what he was thinking as to his trial strategy with the information? Let's assume he did know. And I mean, how do you meet your burden that way?
Yeah, I think that's a great question.
Yes, thank you.
All compliments are appreciated.
The answer is ultimately it doesn't matter, right? Because we either have a Brady violation or an ineffective claim, right? If he didn't use this, he didn't present this, he's ineffective. If he didn't get this, he's ineffective.
Well, I guess, I mean, I see that, except for, that's why I asked the kind of second half of that question is, he may have had a very rational and reasonable explanation for why he didn't use it. Now, he may still end up being deficient and ineffective because of it, but we don't know that. That's where I'm struggling with this. Your argument makes complete sense to me, except for the fact that we don't know what counsel was thinking, what he knew, and why he did or didn't do what he did.
Absolutely. And to answer your first question more directly, yes, it does make it more difficult when trial counsel is deceased after the fact. Certainly that wasn't my choice. Certainly it's made more complicated. Luckily, when we look back in the record, volume 6, page 159, this is when Merritt, the investigator, the first hint that there's other people involved with the death of the witness, the first hint of it, what does trial counsel say? Give me jinx material. Give me jinx material. Give me jinx material about what this guy knows. This prosecutor, you've got to give it to me now. And on page 172, the trial court says, you're not entitled to that information because that's a pending investigation. So when we go back to your question, is it okay if 2 prosecutors do this in one office? The answer is no. That's scary if that's the way our system is set up. But even scarier is when the trial court is preventing that also. The trial court is the one that said, you can't have that information. A lot of the state's argument today and in their brief relies on the same trial court who reviewed this is the same trial court that back then said, you can't have that information. That's a pending investigation. I'm not going to give it to you. And
Right at your time, counsel.
And so ultimately we would ask for the conviction to be set aside and Mr. Bohanna to have his day in court.
All right, we're going to take the case under advisement. Unless you have any questions, any further questions. Let me just say this, for a case that obviously has a lot going on, both parties have presented good briefs and excellent, passionate arguments to the court. We really appreciate that and thank you. We will be in recess until the call of the next case.